I would like to welcome you to Africa in the Moot lecture with Gary Bourne. If I can kindly ask everyone to mute. Thank you. We're so excited to have Gary Bourne joining us this Saturday afternoon as part of our training series for the Willem C. Vis Moot. Of course, what we learn today will be of use not just to the students, but arbitration practitioners. So allow me to introduce our moderators. We have Michael Witzorek and Leticia Busso. Michael is one of the founders of Africa in the Moot, and he is a senior associate at Taylor Wessing, and he is heavily involved in coaching the teams that are part of Africa in the Moot. Leticia is an international arbitration paralegal at William Hill, and she is also a coach to one of our teams in Africa in the Moot. I forgot to introduce myself. I'm Tabitha Joy Rare. I am a senior associate at Anjawala and Kana law firm in Nairobi, Kenya. I am a training coordinator at Africa in the Moot and also a coach to one of our teams there. So without further ado, we would really like this training to start. So kindly allow me to hand over to Michael.
Thank you very much, Tabitha, for the kind introduction. It is my pleasure as well to welcome Professor Gary Bourne here today, and I got the pleasure as well of introducing him. Well, he doesn't really need an introduction to the moot court world. He is a partner at Wilmer Cutler Pickering Hale & Dorr in London, where he also chairs the international arbitration practice. He is a president of the president of the Singapore International Arbitration Center. He has participated in, and I counted from the website, around 1,000 arbitrations, I would say, as a counsel, as an arbitrator. And he has also a very long history with arbitration in Africa, where he has been involved in several arbitrations. So we have probably one of the, or even the best person to speak about arbitration here to us today. Gary Bourne is mostly known to arbitration students and Vismoot participants because of his treatises on arbitration that everybody cites. And I always tell the small anecdote that some coaches even teach, if you don't have any authority, just say Gary Bourne, because he certainly said something about whatever it is you're arguing. So without much further ado from my end as well, Gary, the floor is yours. We're happy to have you here.
Thank you very much, Michael, and good morning, good afternoon, good evening to everybody who took the time to participate today. Thanks in particular to Tabitha, to Michael, to Leticia, as well as Africa in the Moot for inviting me here, and perhaps most importantly of all, thanks to all of you. It's a beautiful Saturday afternoon, at least in some places. I appreciate your taking your time to be with me, to listen to me today. As Michael mentioned briefly, I've professionally, but also personally, had a long history with Africa. I represented Eritrea in the Zucker-Hanish arbitration against Yemen, and the SPLMA, the Sudan People's Liberation Movement / Army, in the so-called ABA arbitration. If you'd rather see me in counsel mode than law professor mode, I'm not sure most of you would want to see me in either, but should you want to see me in a different mode, by all means, look on YouTube, the oral proceedings in the ABA arbitration, which are quite interesting. They were conducted in the Hague Peace Palace before a very distinguished tribunal, are available for viewing, and I know at least some people find them quite interesting, especially if you are either in Africa or have an interest in Africa. That, though, as you know, isn't the topic of my comments, my remarks today. Instead, my remarks today, and this was a request from Africa in the Moot, was to speak about drafting international arbitration agreements. This may not be exactly what you're faced with in the vis moot. It typically involves problems that have arisen when an arbitration agreement already was drafted in the past, and people are fighting about both what it means and what the disputes that it provides for arbitration to resolve, what those disputes mean. But still, I think it's critically important for both younger and also more senior lawyers to think about why you draft arbitration clauses the way that you do, what kinds of do's and don'ts we should pay attention to in what one would think is the very easy, the very simple task of drafting an arbitration clause. And as we think about drafting an arbitration clause, we also inevitably need to think about the problems that might arise from our drafting efforts. So Letizia has not hopefully going to mute me, because if so, my slides aren't like Siri, they won't talk to you. But Letizia, if you can try and share the slides, that would be tremendous. Good. So, and if we could go full screen on that, what we're going to talk about is, and we get a little bit of a bonus here, not just arbitration agreements, also a brief look at choice of court or form selection clauses. But let's move to the next slide and think, why is it that almost all international commercial contracts have in them dispute resolution provisions? And by dispute resolution provisions, I mean typically some sort of choice of dispute resolution mechanism, arbitration, selection of a specific national court. And I also mean choice of law provisions. These two sets of provisions are different, but they almost always go hand in hand. Choice of forum clause describes the legal seat or forum in which a dispute will be resolved. It addresses the procedures in most respects, future dispute resolution. Choice of law clause does something different, but related. It selects the substantive law that will be applied in that future adjudicative or dispute resolution mechanism. Why is it that almost all commercial contracts have such provisions in them? It's for some simple reasons. It's to avoid either unreliable foreign courts or alternatively unpredictable results. Most parties to commercial contracts, cross-border commercial contracts, don't want to be on their counterparty's home turf. If you're from Nigeria, you're contracting with somebody from England, you don't particularly want to be in English courts where perhaps the English party enjoys a certain advantage, and the English party, for its part, typically won't want to be on your own home turf in Lagos or wherever for a dispute to be resolved. There's also a number of courts around the world. I wouldn't include Nigeria or England in this, but a number of courts around this world where there are issues of corruption, lack of expertise, long court delays. In some countries, I recall asking local counsel for when we could expect our case to be listed for an appeal, and it was literally a decade in the future. Commercial parties who want to go on with their business, get their disputes resolved promptly and efficiently, really want to avoid that sort of thing. Language, of course, is also an issue. Very importantly, in commercial contexts, is avoiding either parallel proceedings in two different countries, or even worse, in multiple countries, 3 or 4. That typically means that you'll spend 2 or 3 or 4 times as much on your lawyers, but also that you may well get inconsistent results with different courts reaching different conclusions, producing exactly the sort of uncertainty and unpredictability that business people don't want. Equally, selecting a particular place to have your disputes resolved typically enhances the enforceability of any resulting arbitral award or national court judgment. There won't be issues about jurisdiction, typically, if parties have consented to a particular forum. And then finally, in part, because of all these various reasons, but for additional reasons, it increases the predictability. A choice of law clause and a choice of forum clause increase the predictability with respect to future contractual disputes, and thus make it easier, hopefully, to resolve those disputes and to keep them from arising in the first place. If one has a better sense of where a dispute is likely to be resolved and by who, and according to what law, then the uncertainty as to how that dispute would in the future be resolved is reduced. It allows the parties to go forward with their commercial, their contractual relations in a more efficient way. Let's move to the next slide. As a consequence of all those various factors, parties almost always include in their commercial contracts either an arbitration or a forum selection agreement. Let's move to the next slide. And that typically, the choice between those, if we could back up just one slide, the choice between those two is a very important choice. Does one select arbitration on the one hand, or on the other hand, perhaps a neutral court? In our Nigerian English example, one could imagine choosing Swiss courts, one could imagine choosing New York courts as a neutral objective forum where neither party would enjoy a home court advantage. Which one of these possibilities, international arbitration on the one hand, national court proceedings on the other, should you select? Should you use an international arbitration agreement on the one hand, or alternatively, a choice of court or so-called forum selection clause? Commercial parties for decades have strongly preferred the former. They've strongly preferred to resolve their disputes by international arbitration. And I think that's true for what I call the 5, or in these pandemic days, the 6 E's. International arbitration is generally, as compared to national court proceedings, regarded as more efficient, more expeditious, more expert, more even-handed, more enforceable, and as I say, in the days of COVID-19, more electronic. And I'll just very, very quickly touch on those 6 E's. Arbitration is typically, not always, because some arbitrations go awry, go off the rails, just like some national court proceedings do. But arbitration is typically more efficient and more expeditious, both because arbitral institutions try and make it so, because arbitral institutions have rules allowing for fast-track proceedings, and because the parties in the arbitral tribunal are permitted great flexibility to resolve their dispute in the most efficient way possible. They're not bound by the formalities, the technicalities that exist in many national court proceedings, and hence the arbitral process can be more efficient and more expeditious. Equally, the arbitral process can be more expert. The parties are permitted in international arbitration. It's one of the defining features of international arbitration to select the arbitrators themselves. And in doing that, the parties typically, who know more about their dispute than anyone in the world and have more incentive to pick people who are well able to resolve their dispute in an expert fashion, the parties are able to select expert decision makers. If you have a construction dispute, you select construction experts. And insurance dispute, you select persons who are experienced in insurance law. And the same for any number of other examples that we might choose. In contrast, national court judges, bless their souls, have to decide all manner of disputes, from constitutional to administrative to tax to criminal law matters. And only occasionally, perhaps never before in the past, will they have had to decide an insurance or a construction dispute, which just happens to be the dispute that the parties have. International arbitration is also typically more even-handed. Arbitrators are required to be independent and impartial. They are chosen for neutrality in a neutral forum rather than either party's own home courts. And arbitration, perhaps very importantly, is more enforceable than national court judgments, national court choice of court provisions. The New York Convention on the Recognition and Enforcement of Foreign Arbitral Awards has nearly 170 parties at this point, including most African states. The recognition of international arbitration agreements as well as arbitral awards is largely assured, subject to only very narrow limitations by the New York Convention. There's no comparable treaty and no comparable treaty likely in the future with respect to either choice of court provisions or national court judgments. The so-called Hague Choice of Court Agreements Convention is likely to be, at least if we're lucky, a dead letter. It has many defects and will no doubt not be adopted by most countries around the world. The parties' ability to select the arbitrators to produce an efficient and even-handed decision, which is fully enforceable around the world, makes arbitration dispute resolution mechanism of choice for most commercial parties. On the other hand, it does lack the possibility, unless the parties specifically provide for it, of appellate review. It provides for confidentiality, which many commercial parties appreciate. And in these days of COVID, when in national courts, remote or virtual hearings are typically possible only with the consent of both parties, in international arbitration, arbitral tribunals both can, and over the past 2 years, have conducted virtual hearings just as efficiently, just as expeditiously, and in some ways in a much more cost-effective manner than historically was the case. Let's move to the next slide, please. All of these various considerations have meant that international arbitration, as compared to national court proceedings, has been the preferred means of dispute resolution in cross-border transactions. There are, of course, exceptions in circumstances where a party need not enforce an ultimate judgment abroad, but rather there are its counterparty's assets situated locally. If the party has a negotiating power, as for example, banks and financial institutions often have, to require a form selection clause specifying its own home courts, some parties will choose to do so. In other circumstances, in most circumstances that commercial parties face, however, they prefer international arbitration as compared to national court proceedings. Let's move to the next slide. And as a consequence, and we can, I think, skip this slide. I'll touch on it as we deal with the next slide. And we've basically touched this slide already in my previous remarks. Parties typically prefer international arbitration. One thing that parties are typically strongly advised against, even if they're going to agree to a choice of forum, a choice of court provision, is litigating on their counterparty's own home turf. You typically will, if you're going to agree to a choice of forum provision, want to select a neutral third country. If you decide to select arbitration, the first question you need to address in implementing that decision is institutional or ad hoc arbitration. Let's move to the next slide. There's a fundamental difference between these two creatures. Institutional arbitration is typically conducted pursuant to a set, usually a fairly skeletal or short set of institutional arbitration rules. Good examples include the ICC, the International Chamber of Commerce, the London Court of International Arbitration, the LCIA, the Singapore International Arbitration Center, SIC, and a number of other institutions around the world. Critically, when the arbitration is conducted pursuant to these institutional arbitration rules, the institution has important roles in the arbitral process. The arbitral institution, of course, is not the arbitrators. The arbitral institution doesn't decide the party's dispute, but it does do a number of important administrative functions and supervisory functions in connection with the arbitral process, which is conducted itself by the arbitral tribunal, which makes the ultimate arbitral award. The arbitral institution, most importantly, selects arbitrators if the parties are unable to agree, considers challenges to the arbitrators if one party doubts the independence or impartiality or the other qualifications of one of the arbitrators, often will conduct various administrative functions in connection with the arbitral process, such as specifying the amount of the arbitrator's compensation, collecting advances on costs or deposits to cover the arbitrator's fees, scrutinizing the arbitral award, and ultimately issuing under its own letterhead the arbitral award. The exact extent of what an arbitral institution does is specified in its institutional arbitration rules, and there can be differences, of course, from one institution to another institution, although broadly speaking, there are many similarities between institutional rules, with most institutions doing things along the lines of what I have just described. Obviously, if you're going to get these things from an arbitral institution, you also need to pay for them. There's no such thing as a free lunch. And all institutional arbitration rules have fee schedules, both for the arbitrators on the one hand and also for the arbitral institution on the other hand. In contrast to institutional arbitration, ad hoc arbitration is conducted without institutional arbitration rules, and importantly, without an arbitral institution to do the various things that I mentioned previously. Namely, select an arbitrator if the parties aren't able to agree, consider challenges to arbitrators, and to scrutinize any ultimate arbitral award for defects with respect to form or failure to address particular issues which had been submitted to the tribunal for decision. Instead of an arbitral institution doing these things, for example, considering challenges to arbitrators, in an ad hoc arbitration, national courts in the arbitral seat will do this, which inevitably brings at least some national courts into the arbitral process. And as a consequence, many commercial parties strongly prefer institutional as compared to ad hoc arbitration. There are a number of other reasons that commercial parties prefer institutional arbitration. One of the most important is precisely the selection of arbitrators and the resolution of challenges, which I mentioned previously. If the arbitral institution doesn't do this, then a national court must do it. And if a national court does it, it's doing something that it just doesn't have that much expertise in doing, and which, to be honest, isn't its main concern or even interest in most cases. A national court that's required to select an arbitrator is doing something quite different from what it usually does, which is resolving disputes between parties. And it's often being required to choose somebody from a foreign jurisdiction as to which it may have very little expertise or experience in choosing people from. In contrast, arbitral institutions' main purpose in life is, with a little bit of an exaggeration, but only a little bit, selecting arbitrators. They have vast institutional knowledge and experience in doing so, and typically their choices of arbitrators are quite reliable. Equally, arbitral institutions are quite experienced in resolving challenges to the independence and impartiality of arbitrators. And for all those reasons, commercial parties fairly strongly prefer institutional to ad hoc arbitration. There's one final additional advantage to institutional arbitration, which isn't so obvious. I mentioned that you have to pay arbitral institutions for their services, and that might make one think that they're more expensive than ad hoc arbitrations, but in fact, the opposite is true. Arbitral institutions try very hard, and I can say this from my own experience at the Singapore International Arbitration Center, try very hard to keep down arbitrators' fees, try to impose fee schedules that will ensure that the arbitrators act with maximum efficiency and expedition. In contrast, ad hoc arbitrations have no such supervisory power looking over the shoulder of the arbitrators, ensuring that the arbitration is conducted both efficiently and expeditiously. And so if we move to the next slide, the overwhelming preference of, and we can skip this slide as well, the overwhelming preference of commercial parties, for all the reasons that you can see summarized on the current slide, is for institutional as compared to ad hoc arbitration. The arbitral institution enhances the case management, if I can put it that way, prevents breakdowns in the arbitral procedure. The rules often have default provisions on things like majority votes for the award, the finality of an award, how to deal with issues of corrections to the award, the arbitral tribunal's competence, and other procedural authority, procedural decisions. And for all those reasons, institutional arbitration is strongly preferred to ad hoc arbitration. And let's move to the next slide, please. And the following slide as well. If you are going to use ad hoc arbitration, which some parties prefer, some parties think that perhaps ad hoc arbitration might be more confidential than institutional arbitration, or perhaps they just an arbitral institution looking over the tribunal's shoulder, even if it is a very benign look. Parties can use the UNCITRAL, United Nations Commission on International Trade Law, the UNCITRAL arbitration rules, first adopted by the UN General Assembly in 1976, revised a few decades later in 2010 and again in 2013. They have default provisions on a number of the issues that I've described, things such as the mechanism for selecting arbitrators, provisions regarding competence, the tribunal's choice of law authority, and the like. But they provide for an ad hoc arbitration, meaning that there's no arbitral institution to do the various case management functions, select arbitrators, and the like that I mentioned previously. But if you are going to agree to ad hoc arbitration, using a set of ad hoc rules, such as the UNCITRAL rules, is a strongly recommended feature. Next slide, please. If you want, and because this is a course on drafting arbitration clauses, if you wanted to draft an arbitration clause providing for an ad hoc arbitration, but with the benefit of the UNCITRAL arbitration rules, you could use something like what is on the current slide. And we're going to come back to the provisions of this type of arbitration agreement in the remaining 30 minutes or so of our talk. Note that you don't even have to adopt the UNCITRAL arbitration rules if you want a truly, purely ad hoc arbitration. You could simply agree to arbitrate without any reference to the UNCITRAL arbitration rules or anything else. In those circumstances, there would be no default rules. Everything that would supplant or fill in the blanks of any failure by the parties to agree upon the arbitral procedure. Rather, the arbitral procedure would be conducted entirely at the discretion of the arbitral tribunal with no fallback or default rules of any sort. Let's move to the next slide, please. So let's assume that we have taken the advice that we've heard thus far and decided that we want institutional arbitration. The next question we would then need to decide is choose an arbitral institution. There's some simple but very important, it might seem over obvious or unduly obvious, unduly elementary advice here, but actually it's stunning in practice how often this advice isn't followed. If you're going to choose an arbitration institution, choose one that actually exists, and also choose one that is both experienced and reputable. You might roll your eyes and say, who in the world would choose an arbitral institution that doesn't exist? I can't tell you how many times in my practice over the last decades, I've seen arbitration agreements that select arbitral institutions that either never existed, parties just made up something, or alternatively, select an arbitral institution that used to exist, but went out of existence some time ago, like a discontinued Apple device or something of that sort. An arbitral institution that might have functioned perfectly in the past, but went out of business decades ago. It's critical, if you're going to select an arbitral institution, to choose one that actually is still in business. Things like, and the example of the DIFC, the Dubai International Financial Center / LCIA, which existed until just a little bit ago, but was suddenly abolished, making sure that you no longer include DIFC, LCIA in your arbitration agreements is critically important. Also critically important is choosing an institution that is both experienced and reputable. Importantly, that is independent from the host state. A number of countries, I won't single out any on this webinar by name, but a number of countries recently have established arbitral institutions, which in fact lack independence, which are in fact controlled by the host state. And although that might be adequate in some circumstances, if you're engaged in a commercial transaction with a state-owned or a state-related entity from one of those jurisdictions, you really don't want to agree to resolve disputes under the rules and administration of that kind of arbitral institution. Next slide, please. There are a number of major international arbitral institutions. You can see a list on the current slide. There are also regional institutions in Africa, Lagos, Rwanda, elsewhere, which are entirely reasonable choices for regional or other arbitrations. But But for major commercial transactions, most commercial parties choose one of the longstanding established arbitral institutions, which you can see on the current slide. Every one of these institutions has its own website. The easiest way to find out about these institutions is to just Google them and click onto their website, look at their rules, look at who comprises the Court of Arbitration, look at what their caseload has been doing in recent years, look at the frequency with which their awards are recognized in different jurisdictions. But like choosing doctors, choosing arbitral institutions is benefited by choosing those with experience, with a proven track record for effectively and efficiently administering cases. Next slide, please. And this slide provides a little bit more detail on what I've just described. It also begins our process of actually drafting an arbitration clause. Every one of these arbitral institutions has its own model arbitration clause. If you click onto the various websites that are listed on the slide, you can find those model arbitration clauses. And although it provides for a rather unexciting, a rather unacademic bit of advice, the best advice for drafting an arbitration clause is KISS. Keep it simple, stupid. And that typically means using the arbitration agreement, the model arbitration clause that is recommended by the arbitral institution that you have selected. As we've seen, you want to select an arbitral institution with experience in the field. You may have particular desires for one institution as compared to another because of your past experience. You might think the ICC is tremendous, the LCIA isn't. You might think that the ICC's amount in dispute mechanism for compensating arbitrators makes more sense than the LCIA's compensate the arbitrators based on an hourly rate and the number of hours that they work. But whichever arbitral institution you choose, use their model arbitration clause. It is possible to amend that clause. You can tinker with it and play with it. It's simply a contractual instrument. It's recommended but not imposed. It's recommended to you but not imposed on you. And you're therefore entirely free to amend or alter it, but do so with caution. Institutional arbitration clauses, and one of the reasons to use them is that they have been based on long experience. They've been drafted to avoid problems that have arisen in the past. And when you tinker with them, when you change their language, you may walk right back into the problems that they were meant to avoid. Make absolutely certain that your arbitration clause specifies correctly by the right name the arbitral institution that whose rules you're arbitrating under. And make sure you only specify one arbitral institution. Don't specify multiple arbitral institutions. And we're going to see some examples of bad arbitration clauses in a moment. Let's go to the next slide, please. And indeed, we've arrived at these. These are things that you shouldn't do when you're drafting an arbitration clause. These are arbitration clauses taken from real life cases. Commercial parties actually did both negotiate and sign these things. But don't use clauses like these. Look at the second one. All disputes arising in connection with the present agreement, so far so good, shall be submitted in the first instance. Oops, that's a mistake. I'll tell you why in a moment. To arbitration. The arbitrator shall be a well-known chamber of commerce, like the International Chamber of Commerce, designated by mutual agreement between buyer and seller. So that's an agreement to agree. An agreement to agree in the future on a particular arbitral institution, as to which we're only told it's supposed to be well known and it's supposed to be like the International Chamber of Commerce. Don't draft an arbitration clause like this. Draft an arbitration clause deciding already what the arbitral institution is. The arbitral institution shall be the ICC or whatever arbitral institution you want to specify, not one that you'll agree to in the future. Note also that this clause makes two other important mistakes. First, it provides the arbitrator shall be a well-known chamber of commerce. No, the arbitrator shall be an individual, a person, a natural person like me and you, who is chosen by an arbitral institution, by a chamber of commerce like the International Chamber of Commerce. The arbitral institution is different from the arbitrator. So don't say that. And equally, don't say all disputes shall be submitted in the first instance to arbitration. If you say that, everyone will ask, well, what about the second and third instance? Why is arbitration only the first instance? And there's a substantial risk that whoever decides future disputes will conclude that arbitration is only a non-binding first step, not the final complete resolution of the parties' dispute. And the basic purpose of arbitration is to finally resolve the parties' disputes. The arbitral award is subject to recognition under the New York Convention, subject to recognition under the UNCITRAL model law, and saying that arbitration is only in the first instance undermines that fundamentally important objective of finality. Also, don't do what's done in the first clause, which references two different arbitral institutions, one of which didn't even exist, the Federal Chamber of Commerce in Belgrade. But it references two arbitral institutions. Your arbitration clause should almost always select just one arbitral institution and do so using its proper name. Next slide, please. If you're going to choose an institution like the ICC, use the model ICC clause, and you can see it on the current slide. This is good for the ICC, but it also teaches important lessons about drafting an arbitration clause. All disputes arising out of or in connection with the present contract shall be finally settled under the rules of arbitration of the International Chamber of Commerce by one or more arbitrators appointed in accordance with the said rules. That clause has in it, properly drafted, a number of important components that we're going to come back to look at. It has the definition of the scope of the clause, all disputes arising out of and in connection with the present contract, and the scope is drafted broadly. It provides not for arbitration in the first instance, but for disputes to be finally settled in the last instance under a specified set of rules, the rules of arbitration, of an institution, the ICC, and then the mechanism of selecting the arbitrators, one or more arbitrators appointed in accordance with the said rules. This would be a valid arbitration agreement. I'm going to suggest some additional things you might want to put into your arbitration agreement, but this by itself would do the trick. It would be a valid arbitration agreement, which you could safely include in a contract. You might want to do some additional things, but this would be a good example of how to draft an arbitration agreement that would work. Let's look at the next slide. We touched on this briefly, but it's a good time in talking about the ICC clause. But let's look at the question of the scope of an arbitration clause. The basic issue there is, do you want a very broad clause or do you want a very narrow clause? Possible formulations that you could see in a clause are all disputes arising under or arising out of this agreement. In contrast, you might say all disputes relating to this agreement or connected to this agreement, arising in connection with this agreement. In general, it's preferable to have a broad clause, all disputes relating to this agreement, as opposed to a narrow clause, all disputes arising under this agreement. That latter formulation is sometimes interpreted to include only contractual and not non-contractual or tortious claims. And parties really don't want to have different disputes, contract claims on the one hand, tort claims on the other, resolved in different forms. It creates exactly the risk of parallel proceedings or multiplicitous proceedings that form selection and arbitration agreements are meant to avoid in the first instance. You can play around with the language of your clauses by adding in things like you see in the third bullet points, all disputes, claims, controversies, questions, differences in connection with this agreement or relating to this agreement in an effort to make it a little broader. Sometimes you see provisions that say all disputes relating to this agreement, including any disputes with respect to its existence, validity, or legality, and occasionally, including with respect to the existence, validity, or legality of this arbitration clause, shall be resolved by arbitration. Efforts to make the clause as broad as possible. It's better to draft a clause broadly because some courts hold that language such as arising under or out of a particular contract doesn't cover tortious or statutory or other non-contractual claims. Next slide, please. So what one might do is to modify your ICC arbitration clause in order to make it even broader. An example is on the current slide. Any disputes, claims, or controversies, the red language is the additional language, relating to or in connection with the present contract, including any question regarding its formation, existence, validity, enforceability, performance, interpretation, breach, or termination, shall be submitted to the ICC and finally resolved according to the ICC arbitration rules. That guarantees a very broad dispute. Sometimes parties want dispute resolution mechanism. Sometimes parties want to do the opposite. Proceed with caution here if you want to have exceptions or carve-outs to the scope of your arbitration agreement. Sometimes parties, for example, want to exclude intellectual property disputes or debt collection disputes from the arbitral process. The difficulty with these types of carve-outs is that there are always border disputes. It's a little bit like the ABA arbitration. Parties in two different places always dispute where their border is. And the same is true with respect to exceptions or carve-outs from arbitration agreements. You never know whether a particular dispute is on one side or the other side of the border. Nonetheless, if your client insists upon some kind of carve-out for a particular type of dispute, it can be done. Next slide, please. One question that comes up particularly in multi-party contexts is, does your arbitration agreement in one contract cover disputes under other related contracts? Examples include, for example, framework agreement, umbrella agreements, and the like, where one contract may envisage a number of other contracts that are entered into in the course of performance. One has to think very carefully about how the arbitration provisions in these different contracts relate to one another. And also, as many institutional arbitration rules do, think about the possibility of consolidation of different arbitrations into a single proceeding in order to get the efficiency that comes from that. Next slide, please. Same thing with respect to multiple parties. Do you want in an arbitration for all the parties to the contract to be capable of being joined or to have the opportunity to be joined in an arbitration that started between only two of the multiple parties to the contract? In general, commercial parties would like that. You can draft an arbitration clause. There's language on the current slide that permits that explicitly. Many institutional arbitration rules also permit it, which is a further reason to prefer institutional arbitration. Next slide, please. Once you've decided then the scope of your clause, do you want it broad or narrow? Do you want there to be exclusions or not? You need to select the seat or the place of the arbitration. You might think that the place is a geographical location. It's a physical destination to which you go and which you must go in an arbitration. That's not true. The place or the seat of an arbitration is not a geographical concept. It's a choice of law concept. In choosing the place or the seat of the arbitration, you choose the arbitration law of that place to govern the arbitration, including, most importantly, the arbitral procedures themselves on the one hand, and on the other hand, the place where arbitrators can be challenged if national legislation permits that, and arbitral awards to be annulled or set aside, again, depending on local arbitration legislation. The place or the seat of the arbitration is extraordinarily important. When you seat your arbitration in Kenya, it gives the Kenyan court supervisory authority over the arbitration and conversely denies Nigerian, South African, Ethiopian, other courts supervisory jurisdiction over the arbitration. Kenyan courts and only Kenyan courts can hear challenges to arbitrators. Kenyan courts and only Kenyan courts can hear applications to annul or set aside the arbitral award. And thus the place or the seat of arbitration is exceptionally important. Next slide, please. And you can see examples on the current slide of all the various issues that are dealt with by the arbitral seat or place of arbitration. It determines whether the New York Convention will apply to the arbitral award. The New York Convention, for the most part, only provides for recognition and enforcement on a basis of reciprocity. And reciprocity is determined by the place where the arbitral award is made, namely the arbitral seat. The arbitral seat will also apply to things like the procedures of the arbitration, the arbitrator's requirements of independence and impartiality. It will apply to, at least in a soft way, to the arbitral procedures, but in a hard way to issues of due process rights, rights to be heard. And it may provide the choice of law, the conflicts of law rules that the arbitral tribunal will use. I said previously that the arbitral seat is not a place, but that was only partially correct. It's not just a place, but in practice, many arbitrations, in fact, many arbitration hearings are conducted in the place or the seat of the arbitration. Critically, they don't need to be. You can seat your arbitration in Lagos and choose 3 foreign arbitrators who never set foot in Lagos. Neither of the parties is from Nigeria. The arbitration is conducted virtually or perhaps elsewhere, perhaps Nairobi or somewhere else. What choosing Lagos, what choosing Nigeria as the seat of the arbitration does is choose Nigeria's version of the UNCITRAL model law and Nigerian courts to administer the Nigerian version of the UNCITRAL model law and international commercial arbitration. It provides the legal framework for the arbitration. But nonetheless, in many cases, parties will conduct for convenience the hearings in the arbitration in the arbitral seat. So you want to choose the arbitral seat, a place that would be convenient to the parties. 2 parties from Peru and Uruguay might not think that Lagos is the most convenient place in the world. They might prefer to go to Mexico City, Miami, or somewhere like that. And thus, choosing the arbitral seat, the most important consideration is its legal framework, its national courts experience with international arbitration, the existence of a robust local international arbitration community, and not so much flight schedules and hotels. Next slide, please. What seats should you prefer given those general criteria? You should choose seats where there's a robust national arbitration legislation. Typically, that means the UNCITRAL model law or some other national arbitration legislation with which parties have long experience and national courts have long experience applying. You should choose national arbitration legislation that gives robust effect to arbitration agreements, that recognizes the parties' freedom to select counsel of their own choice and to select arbitrators of their own choice, that provides for minimal judicial review of arbitral awards and minimal supervision of the arbitral process, but nonetheless provides some measure of court assistance, for example, with respect to provisional measures and taking of evidence. The adoption of the UNCITRAL model law and international commercial arbitration is a good proxy for all this. Next slide, please. Here's some examples of where historically, this is 2014, I apologize for it being slightly dated, where parties historically have selected their arbitral seats, at least in the somewhat Eurocentric ICC arbitrations. I think over the past 5 years or so, places like Singapore and Sao Paulo, to some extent New York, have moved up fairly significantly. Some Swiss places, Geneva, Zurich, have moved down somewhat on that list, but there's a remarkable degree of consistency in this list. Next slide, please. And we can skip this slide, I think. How is it that you select the seat of arbitration once you've chosen it? It's very easy. It's in the red font on this slide, and you only need to say the place or seat of arbitration shall be, and then name both a city and a country. It's important to name not just a country, but also a city. In some places like Switzerland, if you don't name a particular city, then just selecting Switzerland arguably invalidates your arbitration clause. Also, don't use words like venue or place of the arbitral hearings. Those things might suggest that you're not choosing the legal place or seat of the arbitration, but only the location, the physical geographical location of the hearings, not the arbitral seat itself. And that's not what you want to do in choosing the place or the seat of the arbitration. You want to choose the legal seat, the legal domicile of the arbitration, whose arbitration legislation will be applicable. Next slide, please. Good practical tips here to pay attention to that I've already touched on in my previous conversations. Note also that you can at least theoretically change the seat from one place to the other during the arbitral process. Do so with extreme caution. It arguably requires the consent both of the parties and the arbitral tribunal itself. Changing an arbitration seat in midstream gives rise to a number of important legal questions, many of which are unanswered. And thus, although you might change the seat by amending a contract before any dispute has arisen, doing so after a dispute has arisen is usually a dangerous idea. Next slide. Appointing arbitrators, and we're almost done with my presentation here. I'll try to go very quickly through this. Is it particularly important in ad hoc provisions to provide a mechanism for selecting the arbitral tribunal? It's often said that arbitration is only as good as the arbitrators that the parties select. That's part of the reason that parties choose arbitration, precisely so that they can select those that will resolve their dispute. But exercising that freedom of choice is critically important. The background, the nationality, the experience, the expertise, the neutrality of the arbitral tribunal is critical to the dispute resolution process. It's important to avoid selecting arbitrators who will be unavailable because they don't have sufficient time, who'll be disengaged because, if I can put it this way, they're past their sell-by dates, who lack experience in the particular subject matter. You choose an insurance arbitrator to resolve a construction dispute. Note that there are complex considerations that go into selecting an arbitrator. The choice of the co-arbitrators can influence who the presiding arbitrator may be, but equally, who the presiding arbitrator might ultimately be can affect who the parties might choose as their co-arbitrators. Next slide, please. One critical issue for drafting your contract is how many arbitrators do you want? The only games in town, in reality, in commercial contexts, are 1 in 3. You virtually never want to choose an even number of arbitrators in some countries. Italy is a good example. Agreements to arbitrate before an even number of arbitrators, 2, 4, or 6, are invalid, unenforceable, for the obvious reason that they may produce stalemates or deadlocks. Even if an arbitration agreement with an even number of arbitrators was valid and enforceable, I think most parties would, because of the risk of deadlocks, want to stay very far away from them. So the real choice is between one arbitrator, who's typically preferred for smaller value disputes, which want to be resolved very quickly, and 3 arbitrators for larger value, more important disputes where the parties care more about getting it right than getting it done a couple months more quickly. Many institutional arbitration rules have default provisions regarding the number of arbitrators if the parties don't select the number of arbitrators. Historically, common law jurisdictions, United States, England, the like, preferred a sole arbitrator and would provide that as a default rule, whereas civil law jurisdictions preferred a 3-person tribunal. For the most part, in institutional arbitration rules, the latter approach, a 3-person tribunal, has prevailed. If the parties don't select the number of arbitrators, the arbitral institution will select a 3-person tribunal. Some institutions, like the ICC, leave the question open until subsequently after a dispute has arisen, so that if it turns out to be a small value dispute, even though it's a large contract, you can select a sole arbitrator. Next slide, please. It's fairly easy to agree upon procedures with respect to selecting an arbitrator. Parties frequently do so, even after a dispute arises. But in the event that parties don't do that, institutional arbitration rules often do have default provisions. Again, that's one of the reasons that parties select institutional arbitration rules that provide for how you will select the arbitral tribunal, including a default number of arbitrators and provisions regarding nationality, like you can see on the current slide, requiring a neutral nationality. Next slide, please. Typically, if you want to select the number of arbitrators in your arbitration agreement, you simply add language that specifies that. You'll recall the model ICC clause provides for 1 or more arbitrators so that the ICC can decide after a dispute arises how many people should be on the tribunal. If you don't want to take the risk of a sole arbitrator, include language which is currently provided on this slide by 3 arbitrators appointed in accordance with the said rules. Next slide, please. Language of the arbitration. It's often said that the most widely spoken language in the world is bad English. But unless you specify the language of your arbitration, you won't necessarily get bad English. You might get Arabic, you might get Spanish, you might get something else. It's essential to select the language of the arbitration, both to avoid disputes about what the language might be, but also because if the arbitration ends up being conducted, for example, in Dutch or Arabic, you'll have a very different type of potential tribunal than if it's conducted in English. It will also affect the choice of counsel and how actively one party might be able to participate in the proceedings. Next slide, please. Selecting the language is fairly easy. You can see language on the current side. The language of the arbitration shall be English or whatever language you would prefer to include there. Next slide, please. Finally, a choice of law clause, and then we'll stop and take some questions. It's important to choose the law governing the contract, just as we have just selected the procedures for resolving disputes arising out of it. Typically, parties want to select a developed, stable, commercially sophisticated law. Favorite jurisdictions include England, Switzerland, Singapore, New York, where you can consult both a body of statutory law, but also a body of judicial precedent that can provide predictability with respect to future disputes. Next slide, please. What do parties do with respect to choice of law? In the overwhelming majority of cases, parties include a choice of law clause here. Some 84% of all ICC arbitrations had choice of law clauses in them in 2014. I think 2014 was a high year actually for contracts with no choice of law clause, 16%, or perhaps 14%. Clauses providing for some sort of lex mercatoria or arbitration ex equio e bono, allowing the arbitral tribunal to decide without reference to law, are very unusual, only 2% of all cases. Next slide, please. I mentioned briefly a moment ago the laws that are frequently chosen by parties in choice of law provisions. You can see examples on the current slide, again drawn from 2014 ICC figures. Next slide, please. And if you're going to draft a choice of law clause, there are again some decisions you need to make with respect to scope. You might say this agreement shall be governed by the laws of Nigeria. Alternatively, and preferably, you might draft a much broader clause. You might draft a clause that has the red language that's on the current slide, which importantly tracks precisely the language of the arbitration agreement that I have laid out previously. Let's move on to the next slide, and hopefully we put it all together. Maybe if we move to the very last slide in the whole deck, Letizia. One of the reasons while we're moving through there, and these slides are meant for your own benefit here. There are a number of additional elements that you can add into an arbitration clause. For the most part, I recommend against these. For the most part, I recommend keeping it simple, using an institution's model arbitration clause, adding in provisions with respect to language, place of arbitration, number of arbitrators, and a choice of law provision. I recommend not adding additional fancy things. And here is a clause which, if you were going to use the International Chamber of Commerce, the ICC, you could use. You would also use it in conjunction with the choice of law clause, although you would note that it is a different provision than, as a legal matter, than your arbitration clause. It's not subject to the UNCITRAL model law and international commercial arbitration. It's not subject to the New York Convention. It's a different legal instrument. So with that very quick whirlwind tour through drafting an arbitration clause, I think we've left just a few minutes for questions. I know there have been a number in the chat box that have popped up, but perhaps if either Michael or Letizia can sort of curate the questions, I'd be happy to answer either things that have been asked or previously, things that were asked previously, or things that you would like to ask now.
Sure. Well, thank you so much for this insight. I think there is a student from Rwanda, Bosco Yakaremie, that wanted to ask a question. So Bosco, if you want to unmute yourself.
Thank you so much. Can you hear me, please?
Yes.
Hello.
I can.
All right. All right. Yeah, I want to thank you for the great session, but I have one question about the law applicable to the formation of arbitration clause. Recently, it was mentioned that the law of the seat usually applies to the arbitration clause, but don't we have some instances where this law of the seat does not apply to the formation of the contract? I mean, to the formation of arbitration clause. And if there are some, please tell us. Thank you.
Yeah, no, that's exactly right. So an important issue, and it's one that frequently comes up in the vis moot, is what law applies to your arbitration agreement. Importantly, you'll recall that the arbitration agreement is a separable contract, separable from, independent from the underlying commercial contract, often the contract within which it appears. The right view, because I say it's the right view, is that the arbitration clause should be governed by the law of the place or seat of arbitration. Unfortunately, the right view has not been adopted, in particular by the UK Supreme Court, which has instead held that in those 84% of all cases where there's a substantive choice of law clause in the underlying contract, that choice of law applies also to the separable arbitration agreement. That decision is mistaken and unfortunate. It was adopted in a decision about a year ago called Inca and just reaffirmed in a case called Kebab G, both of which more or less adopted the rule that I've described. The rule's a little more complicated, and I won't go into the details of the complexities at the moment. But the UK Supreme Court and some other national courts have held that the law chosen by the parties to govern the underlying contract also applies or presumptively applies to the arbitration agreement. In my view, that is an erroneous and also unfortunate decision, because it detaches the arbitration agreement from the legal system with which it is most closely associated, namely the law of the arbitral seat, which will govern almost everything occurring in the arbitral process, much of which is also governed by the arbitration agreement. And unfortunately, the Inca and Kebab G decisions usher in a wealth of complexities, uncertainties, and future contradictions. I don't have much by way of expectations that the UK Supreme Court will correct its errors, but we can all at least be hopeful that other countries won't repeat them.
Well, I think there was, well, thank you for your answer, first of all. And I think there was another question. I think somebody asked, what happens if you pick an arbitral institution, but then in the meantime, the arbitral institution ceases to exist? So how do you address that?
And that's a very timely and pertinent question, given what's happened with the DIFC LCIA, where the DIFC, at least as most observers have concluded, ceased to exist a month or so ago. And despite that, there are many contracts that are still in force with DIFC LCIA clauses in them. In my view, the correct answer to that is as follows. The parties have agreed to resolve their disputes by arbitration, and they have specified a mechanism for doing so, namely DIFC LCIA arbitration. An event has occurred which has made it impossible to conduct the arbitration pursuant to that mechanism, namely DIFC-LCIA. Importantly, that does not make the arbitration agreement invalid. Rather, it makes it impossible to perform the arbitration agreement in the way originally envisaged, and as a consequence leaves you with one of two things. A, an ad hoc arbitration agreement, because you get rid of the term of the arbitration agreement that is impossible to perform, the IFC-LCIA arbitration, but you keep that which is possible to perform, namely resolve your disputes by arbitration. But because there's no institution anymore specified, it's an ad hoc arbitration. Hopefully the parties have selected an arbitral seat, and then the arbitration would be conducted in that arbitral seat with the national courts in that jurisdiction having supervisory jurisdiction. Alternative B is that you conclude, especially if the parties have selected an arbitral seat, that the parties intended to have an institutional arbitration in that place with the institution that is closest in characteristics to that which went out of business, namely the IFC-LCIA. That's a difficult question in these circumstances. Would it, for example, mean an LCIA arbitration seated in Dubai? It might. DIFC-LCIA, if the DIFC no longer conducts arbitrations in conjunction with the LCIA, maybe it's just LCIA. There's a fair argument to that effect. Alternatively, perhaps a local arbitral institution, the Dubai International Arbitration Center, DIA. That would certainly also be a possibility. One of the real risks that arises when an arbitral institution goes out of existence is that exactly these issues are thrown up. And even if you've written long books like I have about arbitration, you can't predict with certainty how that issue would be resolved. It also underscores the importance when you're selecting an arbitral institution of choosing one with a long history and established track record. They're less likely to go out of existence than newer entrants.
Thank you very much. I think there's still another burning question, that is, what is the position of the doctrine of separability in an instance where the contract provides for the seat of arbitration and then there is another seat provided in a separate arbitration clause that binds the parties to the dispute?
So that's an interesting question. I've never encountered it in practice. And so it's difficult to answer it in any conclusive way. I think a lot would depend on the question's starting premise, namely, what does it mean for the contract to provide an arbitral seat? Ordinarily, contracts wouldn't do that, and it's a little hard to think how one contract might. I mean, most likely what you would have would be an arbitration clause with two seats, which, a little bit like an arbitration clause that chooses two arbitral institutions, is a really bad idea. It's not true that you can't get enough of a good thing. You can get too much of a good thing. Choosing the arbitral seat is a good thing. Choosing two arbitral seats is a bad thing because it creates confusion and uncertainty. National courts faced with two arbitral seats typically allow the claimant to choose the one that they prefer. I don't think any of this affects the separability of the arbitration clause from the underlying contract. The arbitral seat is something that relates to the arbitration clause specifically. Even if it's nominally contained in the underlying contract, it would be viewed as part of the arbitration agreement. And thus, I don't think it affects the separability of the arbitration clause.
So, Gary, I have a follow-up question on one of your answers that you just gave, and I'm going to put it in a little bit of a broader context. Let's say we have an arbitration clause that has some sort of a defect, which may be a reference to an institution that doesn't exist, or a wrong reference to an institution. And some institution in that place where that institution that the party's named is supposed to exist says, well, that could be us, let's proceed with the arbitration. What would you recommend arbitrators to do in light of enforcement, in light of setting aside, because we have seen many courts who have used minor defects in the arbitration clause to say that there was no agreement to arbitrate in the first place. Would you proceed, or?
Yeah, so I mean, it is an important and a more general question. Notwithstanding the advice that I've given about keeping it simple, notwithstanding the existence of model arbitration clauses, which you can quite literally cut and paste out of your browser, commercial parties not infrequently try to reinvent the wheel, and they draft provisions like the badly drafted provisions that we saw in the middle part of my presentation. What is the status of these defective or allegedly defective arbitration agreements? An early Secretary General of the International Chamber of Commerce, Frederick Eisenman, wrote a famous law review article called Pathological Arbitration Clauses, in which he described a dark museum of arbitration monsters. That's how he referred to these pathological clauses. And he made fun of all kinds of drafting errors. And given his experience at the ICC, he had a very rich store of ugly monsters from the arbitration world. I take a kinder view. I take a different view. I don't think we should treat poorly drafted arbitration clauses as monsters or pathologies like some COVID-21 or something. Instead, I think defectively drafted arbitration clauses are like sick children or sick relatives. They're things that we should take care of. And I think I'm fair and correct in saying that most national courts take the same view. They view the parties' agreement to arbitrate as expressing their predominant purpose, their predominant desire to resolve their disputes in accordance with the 6 E's in an efficient, expert, enforceable manner. And that if they've made mistakes in expressing that purpose, the role of a court is nonetheless to give effect to the fundamental agreement to arbitrate, and therefore to either write out of the clause the defects. For example, if you refer to a non-existent institution, you blue pencil out the mistaken reference, or to find a commercially reasonable mechanism to give effect to what otherwise might be confusing or arguably contradictory provisions, the selection of 2 arbitral seats or 2 arbitral institutions being a good example. Does that mean that you have to conduct an arbitration in 2 different places or according to 2 different institutional arbitration rules? No, of course not. What national courts have done, most national courts, is to provide that the claimant gets to choose between the 2 seats. Or alternatively, between the 2 arbitral institutions, which one does he or she wish to use? And I think this approach towards so-called pathological arbitration agreements is a more enlightened approach, more in keeping with the parties' true commercial intentions. I think arbitral tribunals, in order to maximize the possibility of enforceability, going directly to Michael's question, ought to attempt to record the parties' agreement to whatever mechanism for going forward has been decided. For example, in what I think Michael's hypothetical was, if you have an arbitration clause that ambiguously specifies an arbitral institution, one party chooses to arbitrate in a particular institution, which says, fine, this ambiguous reference is a reference to us. The arbitral tribunal ought to encourage the parties as best it can to accept that choice rather than objecting and reserving potential future jurisdictional objection. My own view very strongly, I have a law review article coming out shortly as well, is that decisions of this character, interpreting ambiguous clauses or silences in arbitration clauses with respect to the arbitral procedure, ought to be accorded very substantial deference in both annulment and recognition proceedings. If an arbitral tribunal or an arbitral institution interprets a reference to New York in the arbitration clause as New York, New York, United States of America, instead of New York, Australia, or New York, Canada. The arbitral institution's interpretation ought to be accorded very substantial deference. And I hope that's provided a bit of an answer. I think we're probably running short on time at this point. And I'd like to thank everybody again for both their perceptive questions, but also very much their attention during the last hour or so.
But thank you very much for sharing your views and your insights on this topic. Before we leave, I would just ask everybody to turn their camera on so that we can take a screenshot for our social media. And also, don't forget to follow us and subscribe to our posts and share them, like them. Awesome.
While we're waiting for cameras to be turned on, thank you also from me and on behalf of Africa and the Moot for being here with us today. It was very insightful, and we look forward to seeing you again, and we will cite you quite often in the Vismoot.
As always.
Thank you.
Well, I would go on taking a screenshot now.
Yes.
Smile. Perfect. Okay. And then I guess we can say goodbye and, well, thank you again and have a good rest of the weekend.
Great. Thank you, everybody. It was a real pleasure.
Thank you. Goodbye.
Goodbye.
Bye. Thank you.
Bye.
Thank you. Bye.
Thanks, everyone. Bye.
Goodbye.
Thanks, everyone. Goodbye.
Thank you so much for this event. We are from Iran, we are not from Africa, but we decided to enjoy this opportunity, and I really am thankful. This is Ali Zaki, and I'm a SCR member. And joined with my team in my law firm, we decided to benefit from this fruitful event. Thank you so much.
Thank you.
I hope we can meet up in Vismoot in a non-virtual version very soon.
Yes.
Hopefully.
Tashakur Mikonam, and nice to have you here.
ممنونم از شما. Thank you so much.
You're very welcome. Looking
you,
forward to
Gary.
seeing you.
Thank you.
Bye.
زهرا جان مرسی شما